Welcome to our new limited series, Housing Unlocked, where we are going to break down complex housing topics and explore advocacy work happening across the state to make housing more affordable and equitable. I'm your host, Stephanie Watkins-Cruz. I'm the Director of Housing Policy at the North Carolina Housing Coalition. Over the next few weeks, we're going to be digging into property ownership, which is a key source of wealth building for many North Carolina families. We're going to be looking at how advocates and organizations are pushing back against the systems that uphold historic inequalities in property ownership. Today is part one of a two-part exploration of heirs property in North Carolina. We spoke with Lauren Brazil and AD staff from Legal Aid of North Carolina about their recent settlement win with the North Carolina Office of Recovery and Resiliency, which has now made it easier for owners of heirs properties to receive disaster relief. Welcome, Lauren and AD. I'd love to start off by hearing more about your work. Can you tell us about yourselves, the Fair Housing Project, and Legal Aid of North Carolina?
My name is Lauren Brazil. I am a co-director and managing attorney of Legal Aid of North Carolina's Fair Housing Project.
And my name is AD Scaff. I'm a supervising attorney and a social worker for Legal Aid of North Carolina.
Legal Aid of North Carolina is a statewide nonprofit law firm. We provide free legal services in a variety of civil matters to North Carolinians across all 100 counties. The Fair Housing Project is a statewide access to justice project of Legal Aid that was founded in 2011 that works to ensure equal housing opportunities for all North Carolinians through education, outreach, public policy, advocacy, and fair housing enforcement.
Wonderful. Let's go ahead and jump into the main topic of today's conversation. Tell us, what is heirs property?
Heirs property is sort of the legal term for family land, community-owned land. When the last recorded deed owner passes away without a valid will in North Carolina, it then passes to their heirs. And that can happen for one generation, it can happen multiple generations, but then the land becomes, again, what's described as heirs property and is owned by all the heirs as tenants in common. For our work at Legal Aid, a lot of the heirs property is like smaller tracts of land where people are living, that is their primary residence. It's been passed down since 2 or 3 generations. A lot of the typical literature that we've seen on heirs property has kind of talked more about these like really big tracts of land where there's like natural resources or it's like farmland. But for us, what we see is, again, just smaller tracts, an acre, sometimes under an acre, where you might have one or more houses where people are living. One of the things we've seen sort of in our work in this space is a lot of misconceptions about what that means when a person is living on or is an owner in heirs property. Some of the things that we've heard is that, they're not like a real owner, or they can't really do anything to the land unless, they can locate everyone, no matter how far and wide they may be scattered. One reason why like education about it matters is educating community groups and individuals about the fact that a person who is an owner in heirs property can make improvements on the land. They're allowed to do that. And they are like a real bona fide owner. Just because their name is not on the deed doesn't mean that they're not like real. Dispelling like those sort of myths is helpful in like sort of the next step of like why it's important, because then it allows individuals and community groups to sort of challenge the traditional, or at least what we've seen, the narrative around it, so that they can sort of access some of these systems that heirs property owners have been traditionally kept out of.
Whenever I think of ownership and land ownership or home ownership, that's one of the biggest ways that people in our country amass wealth. I can imagine this has a lot of ties and impacts to generational wealth building, or whether or not people can successfully do that or access that, especially if they don't know their rights. Do you have some examples of, from the disaster relief standpoint, how this comes into play as well?
Like a lot of the narratives we've seen around heirs property is, again, like about farmland and natural resources. But when we're thinking about like smaller tracts, there's still generational wealth there as well, right? And value to having family owned land that, you can go to if you need to. We've seen families that we've worked with where, maybe they live there for a little bit and then they get back on their feet and then they go somewhere else, or they've lived there their whole lives. And so again, like it can look different for different families. But when an owner and heirs property is kept out of traditional financial means of like assistance. So not just disaster assistance, but also like if you think about like land ownership, upkeep of your home, there's lots of repairs that you might can do on your own. But then once you sort of move past that in need, like, such as like a home equity line of credit, right, to like make bigger repairs, and then banks are not allowing you to access that type of assistance, then homes can fall into disrepair. They're at risk of condemnation or people just being displaced because they can't live there. It becomes unlivable. And then you also see where there's property owners are more vulnerable to predatory lending, right? So they can't get into these traditional financial institutions. So then they're more likely to go to predatory lenders because they need money to upkeep the home. The other place we see is especially like aging in place. So people are aging in place. They want to stay in their homes. They want their homes to pass on to their heirs, to their children or whoever else in the family. And property taxes become a lot if you're living on a fixed income. In North Carolina, there's the homestead property tax exemption, so it can offer property tax relief if you're over 65 or if you're permanently disabled. However, if you are an owner in heirs property, your tax burden is only reduced by the percentage that you own the property. So if I've lived there my entire life, taking care of the land, et cetera, but I technically own like 10% of the land based on like how many other owners there are, then I can only get it reduced by that amount. If you can't continue to pay that bill, you're then at risk for tax foreclosure, which is another like way of like losing land, sort of losing out on that, again, generational wealth, that equity building that comes from like having family land.
Wow. So there's definitely, I think, complexity there. It sounds like when it comes to heirs property, not just, when the property is transferred over or not transferred over formally, but as they exist, like throughout the lifetime of the property, some barriers that people can have when it comes to accessing resources. I imagine this also has sort of a disproportionate impact on marginalized communities or communities of color. And so I'm interested from a fair housing perspective. Lauren, if you could talk a bit about how you view heirs property from that point of view.
There's decades of research that have looked at heirs property and where the parcels are located and who the owners are. And the research does show that it is disproportionately owned by Black homeowners. We've also done our own internal analysis of heirs property data. And I think the data that is becoming available, and we're learning more, and there's new methodologies that are coming out and trying to measure truly what the impact is. But it does seem both in other parts of the country, as well as in North Carolina in particular, that owners of heirs property are disproportionately Black, or the parcels are located in disproportionately Black census block groups. That is part of what led to our fair housing case in the disaster relief context.
Thanks for connecting those two. Could you tell our listeners a little bit about that case and leading up to it? What was it about and the outcome?
In around 2020, our legal aid staff started seeing that many low wealth rebuild applicants in disaster impacted communities that were impacted by Matthew and Florence were struggling to get through the rebuild application process and to actually secure rebuild assistance. And so we convened working groups here in Durham with our staff from our disaster relief project, our EJI project, and our fair housing project to examine some of the barriers that our clients were facing and to see if we could identify any patterns. And one of the patterns and issues that we were able to identify as impacting numerous clients was that owners of heirs property, there were additional burdensome requirements on their proof of ownership, with quotes, right? How they were required to prove ownership to be eligible to even move forward in the rebuild application process, right? There were certifications and additional documentation that needed to be provided. And it got to the point where what we saw is that many owners of heirs property were not actually able to get through the process. And so we look at that issue through a racial equity lens and through a fair housing lens. We look at the data, the research. The Federal Fair Housing Act is one of our most important civil rights statutes when it comes to housing. It prohibits discrimination in housing because of race, color, religion, national origin, sex, and disability, and then familial status. The Fair Housing Act prohibits intentional discrimination because of race, but it also prohibits what's known as disparate impact. And disparate impact is a legal theory to proving discrimination that has been reaffirmed both in our courts in the Fourth Circuit as well as the United States Supreme Court. What it really is that, well, sometimes there are these seemingly neutral policies, right, that don't call out a protected class, but these policies disproportionately impact or deny equal housing opportunities because of a protected class, or disproportionately impacts protected class members. When we identified the rebuild policy and then we looked at the data, we saw that the applicants that were applying for this program or that would be eligible to apply for this program were disproportionately Black, and the properties are disproportionately located in Black census blocks. We looked at that and then ultimately ended up filing an administrative complaint with the U.S. Department of Housing and Urban Development. Now, your fair housing rights can be exercised both in court and or with an administrative complaint. HUD also has compliance review authority under the Fair Housing Act and a few other civil rights statutes. And so we filed an administrative complaint challenging the policies and practices related to the proof of ownership requirements as they applied to owners of heirs property, and argued that it was disproportionately denying equal housing opportunities to Black applicants. So it was discrimination because of race. Now, that's only one step in this burden shifting analysis, right? So we argue we've identified this policy, we've showed there's a disparate impact, but then the program gets to say, well, we have these legitimate non-discriminatory reasons for having these additional requirements. They present their reason, and then it comes back to the complainant or the person complaining about the policy to say, well, we think there's a less discriminatory alternative to that policy that still meets programmatic concerns that you may have and still addresses your goals without having such a significant disparate impact. In this case, in 2021, FEMA had changed their proof of ownership requirements for owners of heirs property to access FEMA assistance. They were reducing barriers for owners of heirs property and allowing self-certification. FEMA funding is similarly subject to Stafford Act funding, and so it addresses those same programmatic concerns that Rebuild had. And through that, that gave us a strong fair housing angle, or what we viewed as a strong fair housing angle. I'm a really big advocate for the HUD administrative complaint process. And one of the main reasons why is because by statute, it requires conciliation, or there's settlement discussions like mediation. And it's required for HUD to offer the parties an attempt to resolve the issue without engaging in costly litigation. It's this alternative way of trying to work out issues between parties. And so HUD offered us and our clients, as well as Rebuild program, the opportunity to conciliate. And we're grateful to them that they wanted to conciliate and to talk through these issues and how they could potentially change their policies to make it more available so owners of heirs property could actually get through the Rebuild application process. And we're able to work out policy changes that we believe opened up opportunities to more owners of heirs property that still met their programmatic concerns, and that resulted in the conciliation and voluntary compliance agreement. Part of that was that we represented our client, but there was also 74 other applicants that were identified as potentially being wrongfully denied because of the proof of ownership requirements that were there at the time, and they were given an opportunity to appeal. Our hope is that we can begin to move these conversations forward. So when future disaster relief funding becomes available, we can implement these similar policies with less restrictive burdens on owners of heirs property who, again, are disproportionately Black, and then hoping to see that in other like CDBG funded home repair programs to similarly adopt these less restrictive policies.
What
was an example of some of the requirements for proof of ownership before that was disparately impacting heirs property owners, and what have been some of the solutions or proposed suggestions?
At the beginning, it was that your name had to be on the deed. And through advocacy efforts, it came off that a little bit, but then it was you had to sign an attestation and have like documentation that you had located all of the heirs and they had given affirmative like consent for you to participate in the program, or you could not locate them. It had the same impact because if you think about 2 or 3 generations where it's passed to heirs, like I've got 5 kids, those 5 kids have 5 kids, it starts to add up. And then, not everybody's like staying there. Because again, like I said earlier, especially for our clients, these are not gigantic tracts of land. And what we were seeing was maybe they located the person, but then they never got that affirmative consent, or this person, had nothing to do with the land, but then was just like, no, I'm not, then all of a sudden, like your second cousin's got power over whether or not you can get this assistance. That's where it was when we filed our complaint, because then we couldn't, even through our advocacy, couldn't get the program to move past that hurdle. Through the conciliation process and then through the agreement, where it is now is that the applicant, all they have to do is they do have to show some like a very basic, like here's the last recorded deed and I am related to that person. I am an heir of that person. And that's pretty much it. And then they do have to say that they have already notified or will notify the other heirs as they see fit. So it takes away that burdensome, like they have to show proof, they have to get this affirmative consent, because again, messy. So they get to choose what's best for their family and like how they notify them. So we're pretty excited about it.
Giving back some of that autonomy back to the person living there and the owner to be able to navigate that family property themselves. That's amazing. It's amazing how an administrative fix can have so much of an impact. And I think that's something that I want to emphasize from the perspective of an organization that does policy work and advocacy work. I think a lot of times it's easy to fall into the trap of thinking that fixes are always big and huge. And oftentimes processes like conciliation, mediation, and then evaluating how our processes may or may not be impacting the communities we're trying to serve, I think is a big deal. And it's one that can be challenging for some agencies to do, especially if they're dealing with federal funds. But just imagining in this kind of context for disaster relief to unintentionally block families or households from aid, and then for the solution to be a fairly manageable administrative fix is just amazing to think about. Not every change comes from a legislative place. Even just that slight change in ruling and what they accept is a big deal.
Especially for like community organizations, like listening and thinking about this. I think one takeaway, having conversations is great. There's lots of where agencies are working with other agencies. It might be government agencies or whoever. And like getting to be in the room and have those conversations is fantastic. But also, especially for advocates, to know like where's the line. We have a good relationship with the North Carolina Office of Recovery and Resiliency. We have worked with them all through. We don't always agree, but we have a good working relationship. But we also had to kind of make that decision of like, okay, we've stalled out. Like, what do we do now? And so we had to make that leap.
That's an important distinction. Although the fix can be administrative, there is still going to be that threshold of if the momentum's not there, or if the second or third or fourth party is not budging, right? What other steps have to be taken? Are there any other recommendations for partners or even folks that are in impacted communities that see this? What are recommendations you have for them and how they can approach this issue, whether from a disaster recovery standpoint or not, from the generational wealth standpoint?
I think our big hope, our whole aim behind the complaint, in addition to like getting people access to this type of assistance, was sort of reframing this, right? We wanted to come at this from respecting the communally owned nature of property instead of trying to like change it to fit into the system, hoping to change the system to respect the nature of the ownership. This type of ownership has been around forever. It's going to continue to be around. Reframing how you think about heirs property and that it's not a problem. Family owned land is not an issue. It's how we treat it that is the issue. And so for groups that are dealing with this and are in positions to sort of think more creatively about how they could still provide assistance, not one size fits all, how can they approach that so that people can still maintain their land and just live in their homes, not lose it.
And I think for recipients of federal funding, the Fair Housing Act includes an explicit mandate to affirmatively further fair housing. Folks that are receiving federal financial assistance and HUD assistance when they're developing their programs, affirmatively furthering fair housing means more than just not discriminating against people. It's taking affirmative steps to reduce barriers to accessing HUD-funded programs and to addressing historical patterns of discrimination and segregation. And so when you look at the historical context of heirs property and why we even have heirs property, I think it's really important that we look at it through this affirmatively furthering fair housing lens and affirmatively look at how we are implementing policies and what are the impact these policies are having and who is being excluded, and are there changes that we can make to reach these marginalized communities that have historically been underserved and who are intended to be served by these programs.
I think those takeaways fit really well. Family ownership is in and of itself is not the problem, and being able to look at how we treat something that is so common, has been common, is, I think, an important way to look at policy change and to look at the different ways that our communities exist on a day-to-day basis. Are there any other takeaways or recommendations that either of you have for our listeners, or if they're interested in learning more, what they should do?
If there are groups out there that are thinking about this and putting together policies that address this, we're more than happy to look at those and help out.
We're a collaborative team, and we appreciate our partners across the state doing this work and serving our communities. And so if we can be a resource to them, we're here. So please feel free to reach out to us.
Lauren, rapid fire question number 1 is, what is a meal that you've enjoyed recently?
Because it's summertime, our family's been doing a lot of grilling and a lot of grilling of shrimp tacos.
What about you, AD?
We've also been grilling, and I grilled some peaches and then did burrata with the peaches.
Final rapid fire question, and AD, I'll start with you this time. What is the song that you really enjoyed this summer?
I'm going to be a cool kid and say Hot to Go by Chapel Roan.
I had to check my Spotify, but you know what song I've enjoyed this summer? The Dolly Parton Pitbull remix of Powerful Woman.
Lauren's answer beat mine.
And that is our episode. Thank you again, Lauren and AD, for sharing with us. You can learn more about Legal Aid of North Carolina's Fair Housing Project at fairhousingnc.org. Make sure to stay tuned for part 2 of Heirs Property Unlocked, where we'll speak with the Land Loss Prevention Project about what they're doing to retain heirs property in North Carolina.